I have the great honor of introducing my longtime friend, Professor Gerard Bradley. You will see in the conference program a long list of Professor Bradley's great accomplishments, his long and distinguished tenure as a professor at Notre Dame Law School, his enormously fruitful, decades-long collaboration with a great Professor John Finnis, directing the Natural Law Institute, editing the American Journal of Jurisprudence. His new role with the also great Professor Hadley Arkes, co-directing the James Wilson Institute for Natural Rights and the Founding. Not to overlook his enormously successful paterfamilial achievements, only one of which I will mention here, his happy parentage of attorney Jennifer Bradley Lichter, Associate Counsel of the Catholic University of America. But I will also raise two matters that are not discussed in your program. I have always taken Professor Bradley as a model for the sort of scholar that I wanted to be. So far as I know, he and I are two of the only people in the legal academy, maybe the only two people, to have been both state prosecutors and now law and religion scholars. Now, you might not think that the two of these have much in common, these two jobs. But one of the truly great features of Jerry's work in law and religion is that he often focuses on the collective side of law and religion, on the relationship between good and bad religion, on good and bad culture and politics. Just recently, I had occasion self-consciously to echo the title of Jerry's recent piece, quote, "The Death and Resurrection of the Establishment Clause," in a piece of my own, though, of course, we were both echoing in our titles an event a good deal older than either of us. There are fundamentally, I have come to believe, two types of law and religion scholars, types that cut across more familiar divisions of ideology, politics, religious commitment, methodological preference, and so on. There are those who find their way into the field through an orientation toward the good of religious free exercise, and there are those who do so through an instinct toward questions about establishment in the broadest sense, establishment as the essential political good and the common thing that unifies people into political communities. I have always believed that Professor Bradley is by native predisposition an establishment clause or an establishment scholar to the core, and an exceptionally fine one. He addresses in his work the problem of the political, that is, the problem of the relationship of religion to the kind of society that we have and the kind of politics that we want. And I have tried in my own work to model some of this, but never equaling, as Dante once put it, il miglior fabbro, the better craftsman. Please join me in welcoming Professor Jerry Bradley.
Well, that is a hard act to follow, but I fear that Elizabeth, that she bought me dinner last night, is going to make me go through with this. But I have to say it's no small honor at all to be not only introduced by Mark, to be welcomed by Elizabeth and Mark and by the Catholic University Law School, but to be, grouped, I guess is the word, with Mark. DiGirolamo, as we're the only two people in the academy doing religion and law who were state prosecutors. He didn't say, and I fear he is a bit jealous, that I'm the only law and religion scholar who was ever the Manhattan District Attorney's Office pimp prosecutor, which I rejoice to say I did for a couple of years in the mid-'80s in Manhattan when there was no shortage of business. But it's been a pleasure already to be here because I've already seen and renewed acquaintance, talked with so many old friends, really too many for me to even try to mention, except for one. And that is that I arrived here after a kind of rocky Uber ride. I arrived a bit late. about an hour or so ago, and I strode in the door right off McCormick Road, and in front of me, just presenting himself, was a former Clemson University basketball star, seated in the front row next to Saunders, my friend Bill Saunders. Now, this is a man who's gone on to a distinguished career in the law, federal prosecutor and sitting district court judge in North Carolina. And talking about Bob Conrad, whose book on Thomas More has been, I think, not only needed, welcomed as it should be, but has made him a bit of a rock star among federal judges. He went on a book tour that took him, I think, across the country. It weighted down his calendar of cases so that the line of litigants at the door of the Charlotte courthouse, I gather, goes around the block. But Bob now has like a real big boy job. And that's because the Chief Justice of the United States recently appointed Bob to be the director of the Administrative Office of the United States Courts, which is quite a responsibility, but it will give him an opportunity to do a lot of good. So that's the way the day started for me here, and it's only been, what did the psalmist say? I've gone from strength to strength because I've seen so many good old friends. But let me get to the matter at hand. I'd say there's no shortage of arresting quotes with which I could open this first substantive talk of this conference. Now here's my choice, and it's from Fides Oratio, part 90. Once the truth is denied to human beings, it's pure illusion to try to set them free. Truth and freedom either go hand in hand, or together they perish in misery. Now, I don't know about miserable, but the subject of my talk, Libertas Ecclesiae, is only intelligible insofar as freedom and truth embrace. For the church's proper freedom just is its sacred duty to preach the saving truth of the gospel throughout the world. Go and make disciples of all nations, Matthew 28. Whereas Pope Leo XIII wrote in 1887, the church cannot renounce this freedom because it is of the essence of the service which she is bound to render. Now, Vatican II's expression of Libertas Ecclesiae is classic. Among the things that concern the good of the church, everywhere to be kept secure and defended against all injury. This certainly is preeminent, namely that the church should enjoy that full measure of freedom which her care for the salvation of men requires. Pope John Paul II said in Veritatis Splendor in section 106 that the risen Christ's mandate to preach the gospel is the very reason of the church's existence. Now, here's a more analytically rigorous way of putting the point. To the extent that any duty to act or abstain from acting is valid, true, sound, or authentic, it strictly entails the liberty to perform it by acting or abstaining from acting. This is true whether the duty is to others or simply a duty. Parents' rights are coextensive with their moral duty to properly raise their children. Religious liberty is grounded in everyone's moral obligation to seek the truth about divine things, divine realities, to judge what's true, and thence to live in accord with the truth. Libertas Ecclesiae is grounded in and commensurate with Christ's command to go into the whole world and preach the gospel to the whole creation, Mark 16. It's nonetheless been a long and winding road for the church, to quote that eminent church historian Paul McCartney. Pope Benedict wrote in Jesus of Nazareth, now I'll quote Benedict, the struggle for the freedom of the church, that is, as he said, the struggle to avoid identifying Jesus' kingdom with any political structure, is one that has to be fought century after century. The Council Fathers wrote in DH, Dignitas Humanae, that as the people of God has made its pilgrim way through the vicissitudes of human history, there has at times appeared a way of acting that was hardly in accord with the spirit of the gospel or even opposed to it. Not until Vatican II did the Church finally declare in the document of the decree on the office of bishops that, and now quoting the document on bishops in Vatican II, to duly protect the freedom of the Church, no more rights or privileges of election, nomination, presentation, or designation for the office of bishop shall be granted to civil authorities. But CF, as we say in the law review footnotes, the Vatican's secret deal with the Chinese communists. Now, I propose in the balance of this talk to do two things, just two things. The first is to describe more exactly what libertas ecclesiae, the freedom of the church, is. The second is to survey its prospects over the next quarter century or so in America. It's not a pretty picture, but beyond that, I cannot see even through a glass, as if darkly. So part one, what is it? Now, sometimes libertas ecclesiae sounds like it's a sovereign prerogative of dispensation from law. I think Donald Trump. Now, Leo wrote in Sapientiae, Leo XIII, for example, it cannot be doubted that the governance of souls was committed to the church alone, such that powers of the political order have no share whatever in it, or from the Vatican II document on bishops. In discharging their apostolic office, bishops per se enjoy full and perfect freedom and independence from civil authority. But these statements of a kind of Trumpian prerogative, or at least their connotations, are misleading. Even if there were no civil law at all, the church would still be bound by reason and revelation, by morality and justice, in all of its dealings, including in its freedom to evangelize the world. Now, where there is civil law, the vast bulk of it establishes for that time and place what justice to others actually requires. That's what determinatio amounts to. Here and everywhere, the church takes ample advantage of the countless provisions of civil law which enable effective organization of its apostolate, corporate structures, accounting practices, banking systems, and the like. And Pope Leo wrote that the church will even give up the exercise of certain rights which have legitimately been acquired if it becomes clear that their use will cast doubt on the sincerity of her witness. And it was said even earlier, give to Caesar what is Caesar's. So, first point, libertas ecclesiae, in whatever direction its connotations or the connotations of some statements of it may direct us, is nested within the political community and its, that is the political community's, web of reciprocal obligations and collective expectations. It's part of the common good. Well, what freedom then does the church claim by dint of its unique status as the true church of Christ? Well, I think the most authoritative answer to that question since Vatican I is actually from Vatican II in Dignitatis Humanae. Now, the key text, the one-page handout, I think is in your hands or in front of you. I'll slow down a bit. You can glance at it. It's section 13 of DH, what's in front of you. And I'll talk about it. I don't intend to read any of it, but you can glance at it. Most of you have seen it before. But this is part 13. Now, by this point, DH has already turned from philosophy to theology, or probably more exactly, from reason to revelation. Now here, that second part of DH, the story there moves from consideration of individual freedom to that not of just any assembly of believers, but to the church established by Christ and the sacred duties given to it by God. This corporate body is unique, uniquely true, one might say, and it would seem to claim a unique freedom by dint of its divine mission. And there, just consult the first sentence of paragraph B. That's what I mean by the unique freedom commensurate or owing to the unique status of the church. Yet, the second sentence of B and all of C and D appear to say something quite different. They appear to say that when all is said and done, what paragraph A in the first sentence of B call for, that is a special, unique freedom owing to the church's divine appointment, is in fact satisfied by the freedom which the first part of DH offers to every religious community. The whole of A and the first sentence of B make the unique revelation-based claim. The second sentence of B begins equally and transitions to the rest of 13, and it's all about the entailments of natural law, religious liberty for any religious community. Now, the natural right to immunity from coercion in religious matters is grounded in each person's obligation to seek the truth about divine realities, to judge, deliberate, affirm, and then live. But the revealed duty of the church to carry out all the functions entrusted to her by the Lord until his coming rests on different grounds than the natural rights of other religious groups. Well, go figure. But the question then is, have the Council Fathers taken us to the numinous heights where the Spirit blows as it wills, only to drop us back down to the broad plain below? Is there nothing bespoke about libertas ecclesiae? Well, there is at least this. D.H. early on famously affirmed the traditional Catholic doctrine on the moral duty of societies toward the true religion and to the one Church of Christ. This is the question of establishment, about which no pope since the Council has said a kind word. Perhaps none has said a kind word since Pius XI. Nonetheless, the Council implicitly affirmed that state recognition of Catholicism as true, so long as everyone's natural right of religious liberty is respected, is morally permissible and often desirable. No other establishment is morally possible, for no other religion is true. Now, Joseph Ratzinger, Pope Benedict, opposed Catholic establishments because, as far as I can tell, he thought they would violate the healthy secularity of the state. Now, Benedict recognized that the German arrangement, with which he was obviously familiar, amounted to a kind of quasi-establishment, but he thought that that involved no recognition of Catholicism as true, and so was consistent with what he thought was the sound basis for political life, which was strictly natural law basis or grounds. Now, for the moment, I'll grant that proposition, that the proper grant, I didn't say concede, but grant the proposition that the sound basis political life is natural law. I suggest in reply to Benedict Ratzinger that there are rational grounds for affirming the one Church of Christ, the Catholic Church, as true. Grounds, rational grounds, that ought to be recognized by everyone, grounds whose cogency is not reduced because so many people do not affirm them. Part 2, America. So the establishment of Catholicism, or of any other church for that matter, is flatly contrary to our First Amendment. Now, the First Amendment has been a very, very good thing for libertas ecclesiae, as practically every American bishop since John Carroll has recognized and said publicly. Catholic bishops have been among America's biggest fans of the First Amendment. Our constitutional settlement is not unjust or contrary to Catholic tradition, for no one maintains that a Catholic establishment is invariably required by justice or good sense. And properly understood, which means today, as it's rarely understood, our constitutional norm of religious, I'll just call it religious equality, that's a rough term, but our constitutional norm does not contradict the truth about the church. For our non-establishment clause is an authoritative stipulation of state incompetence, not a claim about religious truth. properly read, our Constitution puts the truth or falsity of some propositions about divine realities beyond the state's ken. Now, speaking of America's Constitution, starting with its year 2000 decision in Mitchell v. Helms, the Supreme Court began rolling back the anti-Catholicism which animated its secularist rampages of the 1970s and 80s. Now, Helms is the case. It's about a modest form of state aid to Catholic parochial schools in the state of Louisiana, I think mostly worn-out computers. Helms is where Clarence Thomas wrote for a four-justice plurality that the court's then extant doctrines about this kind of case were born of anti-Catholic bigotry and should be buried now. 2 years ago, in Kennedy versus Bremerton Schools, the court finally buried the three-part Lemon test, which made our public square naked. And thank God that it did. In 2012, in the Hosanna-Tabor case, the court affirmed the freedom of churches, indeed of all religious employers, to control what we might call their messaging. The court wrote, this is from Hosanna-Tabor, requiring a church to accept or retain an unwanted minister interferes with the internal governance of the church, depriving the church of control over the selection of those who personified its beliefs. Imposing an unwanted minister infringes a religious group's right to shape its own faith and mission through its appointments. So that's the ministerial exception case. So far, I say it's all good signs. But the future of Libertas Ecclesiae and constitutional law over the next quarter century or so is fraught with peril. The progress in constitutional law, by which I mean by that is the court's decisions, the progress since Mitchell v. Helms has been welcome and significant. It has also been incremental and ad hoc. Many of the majority opinions in these cases since 2000, reaching the right results, in my judgment, have been one-off, fact-dependent victories for believers. Here, for the inside baseball players, I'll just mention case names Masterpiece Cake Shop and Fulton, which is the Philadelphia Catholic Social Service adoption case or foster case. Many of the other victories have been free speech cases with welcome implications or reverberations for religion. This is 303 Creative and the Kennedy case from 2 years ago. Many opinions have been poorly reasoned, and a couple have been shambolic. All told, these holdings are radically under-theorized. They're shallow. They're suffused with unsupported claims about clear constitutional commands, overfine distinctions, and superficial analogical reasoning. The philosophers in the room are saying, of course, it's lawyers' work. Well, they're like a house built on sandy soil, easily knocked down by a Supreme Court with 2 new Democratic appointments. What the court needs to do ASAP is to consolidate these recent holdings, thematize and fortify them by a masterful majority opinion rooted in unbiased history and sound, and I'm going to emphasize, sound normative thinking about religion and the common good. Now, I emphasize that point. Sound normative thinking about religion and the common good. Because the rot in our church-state corpus goes way beyond repair now, strictly or only by legal reasoning. It owes to bad philosophy. Now, sometimes, like this time, the antidote to bad philosophy has to be good philosophy. But that's going to be a heavy lift for our conservative court majority, which professes not to make valued judgments. And here's another ominous portent. The court will likely, not certainly, but likely soon, grant cert review in a classic church autonomy case, one about the property rights of contending factions of religious congregation rent by schism. Then, when the court grants cert, the simmering argument among scholars about the continued viability of judicial deference to hierarchical church authority will be in the dock. Many respected conservative church-state scholars maintain that only a neutral principles approach to such matters passes constitutional muster. They would do away with the hierarchical branch of the church autonomy doctrine. Let's hope they don't persuade the Supreme Court that they're right. Now, more ominously, in Kennedy 2 years ago, the court rightly abandoned the secularist Establishment Clause test minted in the 1971 Lemon case. But rather than replace that bad doctrine with good doctrine, the court in Kennedy 2 years ago decided to abandon doctrine altogether. So rather than fall back in Kennedy, after rejecting Lemon, rather than fall back upon a sound, defensible norm or test or rule or a stand-in, the majority went to its originalist safe space, namely history and tradition. The Kennedy court wrote that the Establishment Clause must be interpreted by, and here's the phrase from Kennedy, references to historical practice and understandings, again from the Kennedy case. The line that courts and governments must draw between the permissible and the impermissible has to accord with history and faithfully reflect the understanding of the Founding Fathers. Close quote. But the founding was rife with legalized anti-Catholicism. To take the gravest example, in 1789, Catholics were very widely barred from holding public offices. They were clearly eligible for public office only in Pennsylvania, Delaware, and Maryland. And the model of church autonomy at the founding was thoroughly Protestant. In a few places, mostly in New England, local government participated in the choice of ministers. Everywhere, there was legally sanctioned lay control of what was then in the materials called church temporalities. Ministers enjoyed, at the founding, a certain freedom to preach and to supervise spiritual things, but that was that. What we might call institutional ministries, mostly charities, were then thoroughly tied up with local government, even where they were actually run by church groups. Incorporation, that is a legal incorporation, was then special, that is, one at a time. General incorporation laws came quite a bit later. So at the founding, any religious body which sought the benefits of legal personality was subject to legislative control, for to the legislature you had to appeal to be incorporated. And it was in the lawmaker's gift. Public authorities at the founding were also very keen to limit the temporal wealth, the money and property of churches, and did so. Now, the takeaway from this, or these facts, is that any return to the founding and church-state matters could be calamitous for libertas ecclesiae. But here we're not actually yet to the heart of the matter, because I've been speaking, so far entirely about what I'll call cognate dyads, church and state, freedom and coercion, liberty and law. Well, fair enough, in the Catholic tradition, two there are: altar and throne, spiritual and temporal authority, the church and the civil power. Some such formulation about power, respective powers, and immunities is the subject matter of almost every authoritative statement of libertas ecclesiae. But I submit that the gravest challenge to that freedom, libertas ecclesiae, in the immediate future is the enervation of the church's freedom due to cultural headwinds. Cultural headwinds buffeted, propelled even, by the law. The law powerfully shapes culture, and in this way has the greatest impact upon the church's freedom, not by taxing, penalizing, or imprisoning, or trying to run the church, but rather the law has its greatest impact upon the freedom of the church by shaping the whole cultural understanding of what religion is. and what proper religious liberty is, and the place of religion and religious liberty in the common good. Now, this relationship between law and culture is not a necessary truth about law. It's not an axiom of social theory or political science. In fact, I think the relationship between civil law and culture in any society is a contingent matter. But it is just a matter of fact, here and now, that where our law goes, the culture won't be far behind. In an article published a little more than 20 years ago, Francis Cardinal George observed, this is Cardinal George speaking, law has peculiar and unique cultural functions in American society. Now, a little bit longer quote from Cardinal George. It's worth the length. The many components of our culture, he said, are largely united by law, not by blood, not by race, not by religion, not even by language, but by law. It's the one principal cultural component we all have in common. Law is more important in teaching or instructing than it is in directing us. One must therefore ask how it is that law functions as a cultural carrier in this country. And what does that mean for cultural institutions like marriage, family, and the church? Just so. In my judgment, Libertas Ecclesiae presupposes for its meaningfulness and requires for its flourishing a culture characterized by a high degree of commitment to religion as a zone of truth, not as an enclave of tradition, custom, identity, projections, emotions, and edifying fables. Zone of truth is here another way of saying that religion is about reality, including especially those parts of reality that are impervious to scientific measurement and tactile touch. Those parts, it's about those parts of reality that are invisible, but can be known. First, by human inquiry, reflecting upon what there is to see and to feel and to touch, by God's self-disclosure and revelation. The various religions, whatever else they are, and they are other things, but at core, they're just so many accounts of what there really is. But if you erase truth from any society's picture of what religion is, I think you decapitate religious freedom and render the duty to make disciples nearly senseless. For you cannot convince someone of the truth of Catholicism if they are convinced by their culture that religion is not the kind of thing that is either true or false. You cannot make disciples of persons who are unable to wrap their minds around the concept of discipleship. Indeed, one cannot be a disciple as opposed to a member or a follower or devotee, save where one cleaves to the faith as truth. And really, how much of the faith could be embraced, frankly, should be embraced, on any other grounds? Now, no one wants to believe in mortal sin and hell. Not many people. But no one wants to believe in mortal sin and hell, or in Satan and all the evil spirits who prowl about the world seeking the ruin of souls. The only rational basis for any decent person to affirm these sobering, fateful truths is to be convinced that they are true. Now, the first rule when it comes for law, the first rule for law when it comes to culture is Hippocratic. Do no harm. Well, the Supreme Court has flouted this one with impunity for decades. Consider first the infamous mystery passage from 1992, the Casey Planned Parenthood case. You can recite it from heart, right? Anybody want? I mean, Judge Cox, well, I don't want to call. I'm not going to cold call anybody in class today. I'll say the mystery passage. At the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life. So there it is. There's no transcendent source of meaning and value. You are the source of meaning and value for you. As Father Guy Mancini wrote in a different context, this radical turn inward changes us from, and here's Mancini's phrase, from hearers of the word to architects of our own spirituality. Now consider next the 1981 Supreme Court case Thomas v. Review Board. There the court wrote that religious beliefs, court said, need not be acceptable, logical, consistent, or even comprehensible to others to merit First Amendment protection. Now this is, or is almost, an assertion that religion is irrational, that faith is superstition, marinating in feeling, imagining, and longing. Now put these together and you have not a disciple or even a believer. You instead have an opaque subject drifting aimlessly in a sea of identity politics. Now any account of religious liberty built on this foundation is an imposture. The cultural critic Philip Reif wrote in 2005 that the Orthodox are in the miserable situation of being Orthodox for therapeutic reasons. They are trapped in a cultural vocabulary of therapy and self-fulfillment. Pope Benedict XVI wrote, if religious freedom were to be considered an expression of the human inability to discover the truth, and thus becomes a canonization of relativism, then this social and historical necessity is stripped of its true meaning. Now, the court had to kill, wipe out, obliterate natural religion to unleash their solipsistic superhero. For if reason affirms and the law confirms truths about divine realities, such as those which were the civic furniture of the American founders, then defining your own universe is not liberty, it's insanity. The laws of nature and nature's God emboldened the revolutionaries in Philadelphia. Before and after the founding, civil governments in America affirmed truths such as God's eternal existence and creation of all that there is, God's providential care for humankind, including God's promulgation and communication of the moral law for the guidance of human affairs. The founders affirmed some form of afterlife in which the guilty suffered and the virtuous prospered, what they called a future state of rewards and punishments. The founders knew, too, that one does not need to have faith in the stricter sense, understood as an assent to revelation on the basis of divine authority in order to pray. Again, you can pray if you're a natural religionist in this way or for this reason. One need only acknowledge the existence of a creator and further see, affirm, acknowledge that the creator is intelligent and free in some analogous sense. For it to make sense to try to communicate with God. This is true, at least in my judgment, for expressions, prayers of thanksgiving and gratitude. I'm not sure if it's true for petitionary prayer. That is, whether based on the tenets of natural religion, one can see the point of praying to God for the sake of an anticipated or desired response from God and answer back. Sure, several of you present can mood that better than I can. But these truths of natural religion reconnect religion with reality, just as they restore the role of reason to matters religious. And these truths are fertile because they make the prospect of intelligible divine human communication, that is to say, propositional revelation, not only possible, but likely. They are, the truths of natural religion, are a preamble to genuine faith. Public affirmation of them makes credible the Church's evangelization and thus Libertas Ecclesiae. Now, natural religion was wiped out by the Supreme Court on June 25, 1962, in the case of Anglo versus Vitale, prayer case. That day, the justices invalidated the following voluntary school prayer. Almighty God, we acknowledge our dependence upon Thee, and we beg Thy blessings upon us, our parents, our teachers, and our country. End of prayer. Now, it's no justification and only a pathetic excuse for this disastrous holding that no one on the court in Anglo in 1862 had the slightest, or at least evinced the slightest awareness that there was any difference at all between that prayer, which is just pure natural religion, and, say, the Nicene Creed. The court compounded their guilt in Anglo by expressly transliterating living affirmations of belief in God into a history-based civil religion. In a footnote, the Anglo court wrote, now the court speaking, "There's nothing here inconsistent with school children being encouraged to express love for our country by reciting historical documents such as the Declaration of Independence, which contains references to the deity, or by singing officially espoused anthems, which include the composer's professions of faith in a supreme being." The court concluded, "Such patriotic or ceremonial occasions bear no true resemblance to the unquestioned religious exercise that the state of New York has sponsored in this instance." Well, I think that the Establishment Clause doctrinal meltdown at hand presents a generational opportunity, actually 2 generations, to reintroduce natural religion into the Supreme Court's Religion Clause jurisprudence. But I do fear that even our best church-state litigators will not seize the moment. Okay, finally, law, culture, church, Libertas Ecclesiae. Even where the state does its part, does right by the church, and where the state encourages a healthy religious culture, to put it one way, the church has to be a productive partner. And Libertas Ecclesiae, it's about the truth about the salvation in Jesus Christ. But if that truth about salvation in Jesus Christ is abandoned or watered down by the church itself, well, so goes Libertas Ecclesiae. Now, universalism, I think, is much, much more common, even among otherwise Orthodox Catholics, than we like to recognize. Now, indifferentism has the same effect as does universalism. Because if it's true that either everyone's ticket is punched to heaven, no matter what, or that all the religions are more or less equally efficacious pathways to salvation, well, I think that then one is obliged by candor and honesty to judge that the black robes who paddled down the St. Lawrence River to bring the gospel to the Huron and the Algonquin, and indeed, we'd have to judge in all candor that the apostles and all the missionaries and all the martyred witnesses to the gospel are fools. They may be admirable, but that would just mean they're admirable fools. Now, I think these deviations, universalism, indifferentism, actually have their roots in the crisis about Scripture in the church. Most Catholic scholars today deny the inerrancy of Scripture and set aside the Catholic standard for its interpretation under the guidance of the Church's teaching authority. Now, here's a sentence from Dei Verbum 18. The Council Father speaking in Dei Verbum. Holy Mother Church has firmly and with absolute constancy held and continues to hold that the 4 Gospels just named, whose historical character the Church unhesitatingly asserts, faithfully hand on what Jesus Christ, while living among men, really did and taught for their eternal salvation until the day he was taken up into heaven. Now, the Catholic bishops have shown no evidence that they grasp the depth and importance of the crisis in Scripture. Just as their priests uncomprehendingly treat the Gospels as what the scholars insist they are, namely, not the words and deeds of Jesus, but the articulated faith experiences of late first and early to mid-second century Christians, communities in ancient Palestine. So, in conclusion, if Matthew is some anonymous guy in Antioch around the year 85 or 90 AD, handing on stuff he's heard around there, the origins and truth of which he does not, cannot certify, and doesn't really assert. And if all the successors of the apostles are just acting on their own personal faith experiences, then I can scarcely imagine why any reasonable person would carry the gospel to the ends of the earth or witness to it at the risk of death. And their Libertas Ecclesiae would then be neither compelling nor even interesting enough to be worth our time today. That's it.